Yes, welcome to the No State Project, back live on Saturday. I'm glad to be with everybody here today. Everyone started filing into this live broadcast from the fortified compound in Mesa, Arizona. Get it right off the bat. I will be live on Wednesday, but next Saturday I will not be live again. But hopefully I can get those other videos done. That I've mentioned regarding the two parts, the law not applying to everybody, but the ruling class being privileged, which is something I'm going to be talking about today. And also the, what do you call that? Anatomy of a frivolous argument. So it is, wow, September 7th already. September 2011, 9/11 is coming up here again real soon. So still don't know exactly who's responsible, although some of the same actors are still in there. Mueller is still, I think he's retired now, but still very, was a very big part of that cover-up. The number here is 218-632-9399, 218-632-9399. The passcode is 2020 with the pound sign if you want to join me on the big show. Got to thank everybody for the continued support of the show. I do appreciate it. Dan and Bill in New Hampshire, and Mark and Don and Eyal and Nelson, Chris in California, and Rob in Seattle. I hope I don't forget anybody, but I do appreciate it. If you want to help support the show, it's I almost did it that time. It is markstevens.sells.com. That's SELZ, markstevens.sells.com, which is linked at markstevens.net, and you can just go to markstevens.net. If you're being attacked by a bureaucrat, you want to learn how to more effectively defend yourself, or you just want to argue better, and be better at detecting BS and holding people to their burden of proof. Because remember, logic dictates that the one who makes the allegation, the one who makes the claim, bears the burden of proving that's actually true, not the other way around, as some would try to get you to believe. And yes, that is something that is a part of the American and the Anglo-American legal system, that the one who makes the allegation bears the burden of proving it. So it's not up to the one that the allegation is made against, or the claim, one who objects to the claim. It's not up to them to prove that they're wrong. It's up to the one who makes the claim to prove that they're actually right. And if they can't do that, so remember what Hitchens said: that which can be asserted without evidence can be dismissed without evidence. Okay. In the legal realm, if there is a certain amount of facts that, if they're taken as true, tend to show that the proposition or the conclusion is right, that's what they call a prima facie. But and that would shift the burden, because now you'd be responsible to either show that the facts are not accurate, the logic is wrong, or you have contradictory evidence to that. I know those in the legal realm, bureaucrats, they like to think that just making the claim gives them an automatic presumption of correctness. This is not true even for the tax people. It has to be based on a reasonable and rational factual foundation. That the foundational claims have to be supported by facts. Are there cases that explicitly state that the specific foundational claims have to? No. There isn't a specific case that I can find, and it's not necessary, that actually says that the foundational claim that we attack, or I attack here on the show, and directly with the IRS, that they have to have facts for that. The legal principle is what is sound here, not whether a judge agrees with it or not. The principle is, and it's always been upheld, the foundational claims. U.S. versus Janus is one of those cases. I don't have the full citation off the top of my head. But if you get government indicted, which has a model for effectively defending against these people, it is in there. But what's important here is that the foundational claim. So some may want to split a hair, but Mark, there isn't a Supreme Court case that actually says that this particular foundation. No, it doesn't matter. If the foundational claim that sets the relevance for the rest of the claim, if that is not based on facts, if that's based on an assumption or speculation, there is no presumption of correctness. Just like the Helvering versus Taylor, the United States Supreme Court said that if a foundational claim is shown to be arbitrary, that's enough to set the whole thing aside, including the presumption of correctness, and then the burden is still on the accuser or the one making the damn claim. So a lot of this information, of course, is in previous shows, and you can also get at markstevens.net. So if you do, yes, I already gave out the caller information. So let's see what we do. We have oh, should I get to the calls already? I don't want to hear the complaints. I'll get to the call in just you know what? Screw the complaints. I've got somebody holding on. Let's get to the calls first, because it's a YouTube video, and most people are going to be watching, and they could just jump ahead. Not that you should jump ahead, but we'll get to the callers here. We have a new caller. We have area code 619. Looks like San Diego. You're live on the No State Project. What's your name? Where you calling from?
Hi. I'm calling from Chico, California.
Oh, Chico. What's your name?
Name's BBC.
That's not the voice I would have attached to that username, but good to have you on.
Oh yeah, yeah. I don't know if you got my email. Have you?
I get a lot of emails, and I don't remember. You probably didn't send it to me under the username BBC.
Yeah. Mm-hmm. Well, it was the one that I had my first rodeo the other day, or a few days ago. Yeah, and what happened was they pretty much went ahead and tried to take it to trial, even though I haven't made a plea, nor have they entered one on my behalf. And I have the whole thing recorded, too, for my record. So this will be, I've already shared it in some of the Discord servers as well. But I'm trying to figure out what I should do next. I am thinking of getting the judge disqualified, if possible. Yeah, that's pretty much it so far.
Well, what's the charge?
Lack of insurance.
Oh, no. Those poor insurance companies. What was the
Yeah.
What was the pretext for the stop, though?
The pretext was gridlock.
Gridlock.
Mm-hmm. What happened was there was a light ahead of me that I didn't see, and because of that, the cars had stopped, and I was technically blocking the crosswalk. And that's what got me to be pulled over, which eventually led to them knowing that I didn't have insurance.
They could do tickets like that all day long in Los Angeles. I know that, like going down Beverly. There was last year. It took an hour and a half. I think was it Beverly Hills Boulevard, or I think it was one of the main roads there in LA. It was an hour and a half or so to go like 5 miles. The cops could have just sat there on every corner for those 5 miles that we were going down that strip, and could have just handed out tickets and met their quota for the entire, quarter, just in that one day, given. Okay. So that's what the pretext of the stop was. Okay. So they're trying to push this. So this is just an infraction, though. They're not charging you criminally, right?
I believe it's just traffic. There's nothing indicating that it was criminal.
Okay. So you wouldn't have to necessarily enter a formal plea of guilty or not guilty anyway, but they want something about responsible, and that you're contesting the ticket to then justify them bringing this to trial. And so since it is probably just a civil infraction, the Brady doesn't apply, but still discovery does. But instead of giving you that discovery a number of weeks before the trial, so that you can actually prepare adequately, and it's not like, but they just had to give it to you the day of trial. And I think it's kind of a dick move for them to do that. However, when we look at, traffic is not a real controversy. It's not a real case or controversy. So it's not something that really should take a lot of time anyway to prepare for, especially in our case, because we're challenging the foundation, where for those who are new, like I've mentioned, if you knock out the foundation of, their foundational claim that creates the relevance or shows the relevance for the rest of the claim, then you don't have to worry about the rest of the claim, because nothing is admissible unless they first establish that relevant. So we're striking at the root. And okay, so what actually happened in court? Give me some of the details.
What happened was I went in, I was a little nervous, of course, because I'm dealing with criminals. The very first thing I had brought up was the motions, and, they told me the whole thing, like they've been denied and reviewed and all that BS. Then I went ahead and the first clarification I had asked was if I had the right to a fair and meaningful hearing, and they didn't answer that. And I think I had said in the record that they didn't answer the question. But eventually, I just went for the meat and potatoes and said, okay, well, what's the evidence, the factual evidence that the prosecutor has brought to the table? And they really didn't want to answer that one. They just said, okay, we're just going to try to set you up for a trial date. And I've objected every single time they've brought up trial.
Okay. Did you try to plead guilty? Did you try to just plead guilty and say that you're guilty, you'll pay the fine if the prosecution has the evidence?
Well, I did say that my intent was to plead guilty, so okay, that's on the record too.
But you want to use that when they don't want to answer the question about the facts and they just want to force the issue to trial. So we try to throw a monkey wrench into the works by saying, hey, I told you I intended on pleading guilty if the prosecution has these facts. There's no reason to set this for trial. We can settle it right now. And that's why we do that. So all right. So because you're talking about disqualification, we'll get to that. Let me just write that down so I don't forget about that there. Let's get back to, the first part of this, because I think you missed an opportunity here. When the judge said that the demur, and in California, everybody, the motion to dismiss, at least the initial one, is called a demur, not a motion to dismiss. Same damn thing. When he said the demur was denied or overruled, did you object and ask, what specifically in the motion, in the demur was not considered to have merit, or rather that the objection so it's your position the prosecution does have sufficient facts to overcome the demur? Did you do that?
I didn't necessarily object, but I did ask on what grounds was the decision made. And I think she said something along the lines of it's a issue on trial or something like that. I'll have to look back at the recording, but I did make it known that I was asking for the reasoning why they made that conclusion.
Okay. Is it better to ask an open-ended question like that, or like what I did, ask a leading question saying objection, so it's your position that the prosecution did have sufficient facts in the record to overcome the demur?
Yeah, it's better to really tighten it and not have an open-ended question.
Yeah. So those listening, you want a leading question, because if you give an open-ended question like that, on what grounds, you open the door for the judge to start with the verbal diarrhea. If you ask a leading question, it's either yes or no, and it puts them into, at least if they're honest, well, we're not going to assume that. But if they go ahead and they lie and they say that, yes, the prosecution does have sufficient facts to overcome the demur, well, now we're in a pretty much better position, because they're up against the wall. They're saying that there are facts to support the foundational claim that couldn't possibly be. Now all we have to do is say, look, I'll cut you a check here today, right now. We can get this off the docket now. What facts in the record did the prosecution present that prove that just because I'm physically in California, that your Constitution applies to me and gives jurisdiction? Now, if they turn around and say, "Abafungul, we're gonna go to trial," if they pull that, now you've got solid grounds for the disqualification. A lot better than from where you're sitting right now.
Yeah, absolutely. Like I do have a recording of it, and is it possible for me to bring this up to anyone? Well, I doubt that they'll actually listen to it, but is it possible for me to put it on the record that I have a recording, or should I just keep that not known and then probably get more information out of them too?
You have a recording.
They didn't know they were recorded.
Yeah, if you recorded them in court, you cannot
Mm-hmm.
release that to them. You can't.
Okay.
You know, I mean, I have a call to shame that I'm hoping that the reason why they sent it to me was because I can post this as a call to shame, where somebody called the police chief, and after it admitted that he had no facts to support the claim he just made, that they operate on the presumption if you're physically in, I don't remember, I think it's Wisconsin. If I'm physically in Wisconsin, then your laws apply and give jurisdiction. And the police chief said, well, yeah, that's the way it works. And then he followed up and said, well, do you have any facts to prove that that's true? He has them on record saying no. Now, I don't know if he let that police officer or chief know he was being recorded. If he did, it'd be great. And we can probably, if he didn't, we got to bleep his name out. We can't give any information. So people have to kind of take it on an issue of faith that it's actually a real police chief they're talking about, and we didn't just make it up. So here, you got to keep that under your hat. You can't use that. Write down what we said, and you can use that. You can quote them. It's better, and he says, look, I just took it from my notes. But here, as far as a disqualification, I think you still can do that because you have a arbitrary denial of the demur, and the judge actually lied, saying that the factual issues were for trial, which is not true. It sounds right, but it's not accurate. There's a prima facie burden that the police officer and the prosecution must meet before you can set the matter for trial. So you've got two different, so for those who are new, you have two different burdens of proof we're talking about here. When the complaint is filed, until you walk into that court on the day of trial, the burden of proof is prima facie. Once you get once the trial starts, the burden of proof ratchets it up, and it is now beyond a reasonable doubt if it's criminal. Here, you're not dealing with criminal, you're dealing by preponderance of the evidence. That is still, yes, it's a higher legal standard, but it doesn't excuse them at the beginning from having a prima facie burden, which is something that the judge just basically lied in, by leaving that out and trying to say, oh, it's a trial issue only. No, it's not. Let me just bear with me for a second. If jurisdiction really is a trial issue only, and I had a judge say this almost verbatim to somebody this past week, if it really is, then you could sue the judge, and he has to wait until the day of trial to argue any motions to dismiss for a lack of jurisdiction because of sovereign absolute immunity. And that is just not the way it works. Anybody saying to you jurisdiction is a trial issue only is lying and bad. And so what I would do first, unless you have a trial date coming up really fast, I would file to reconsider the denial of the demur. And I have a template for that. You email me to remind me after the show. Give the judge the opportunity.
I think I already have it.
Oh, you already have it?
Yeah, I got all the documents.
You already have a motion to reconsider the demur? All right.
Oh, the demur.
Yeah.
Well, you gave me a motion to reconsider at some point in the emails that we sent each other.
Oh, okay.
I'm not sure if they're different. Yeah.
I haven't sent one for California that I know of in at least a month or two. So just get with me, go through your stuff, make sure you have to reconsider the demur. And if you don't have it, get with me, and I would file that first. But I would put in there, you want to make sure that you edit it with your facts as to what happened here, that the judge clearly denied the motion without considering the facts and is covering for the prosecution, and then try to mislead you into thinking that the issues that you raised were trial issues only, when they absolutely are not. And those facts. I'm sorry?
I wanted to add something too. Like, also in the recording, I had asked the judge if jurisdiction was a trial issue, expecting to get a yes and all of that, and I was going to trap them and tell them, okay, well, how is it that, there's court cases saying that jurisdiction can be challenged and yada, yada. But to my surprise, they said no. and they wanted to say, okay, well, we said no, but we're going to try to set up the thing for a trial. I'm saying, well, you said no. Well, they asked me, do you want to set up for a trial? And I said, well, if it's the case, then no, I don't want to. So.
Look, I intend on pleading guilty. Like I told you guys, I'll pay the fine right now if the prosecution has met their prima facie burden. I'll pay it right now.
Mm-hmm.
That's the way I would play it. We've done it with the IRS, and they sent us one. They threw us out of the office. It's happened multiple times. So that's what I would do on that, as long as you have at least a month before there's any kind of trial.
Yeah, I saw time. I think it's the 23rd is when they want me there. So.
No, you have time for that. You, if it's the 23rd and it's the 7th at this point, because if you file to reconsider, they're just, they may not deny it for a few weeks. And then you're showing up for trial, and now you want to change the judge. Now, prosecutors can walk in the day of trial. I've had it happen. There was a Michael Ortiz who is the judge, and he was sticking to the rules. He didn't give a damn. I was like, man, I got a chance here. And the prosecutor walked right up to the bench, filed a motion to disqualify. And moments before the trial was supposed to start. And the judge, Ortiz, he says, I'm sorry, sir, with all due respect, Rule 8, I'm done. I have to pass this off to the presiding judge and to be reassigned. And that was it. And it got reassigned. Somebody who wasn't quite a stickler for the rules. So if you've got it coming up on the 23rd, what I would do is file a motion to disqualify with all the issues we put in the motion, basically in the motion to reconsider. And just like I covered with you, that she arbitrarily denied the motion, the demur, lied, trying to make it look like jurisdiction was a trial issue only. And you can't possibly get a fair trial from someone who's going to mislead you on the procedure in favor of the prosecution.
Absolutely.
Yeah, seems like a no-brainer. So that's what I would do. I do have a template that I can send you for that, but you're going to have to put your own facts in, obviously. See, and for those listening, what you have, unlike with the prosecution, if we're going to have a legal conclusion that the judge should be disqualified, we have to have facts to support that. And since the judge has already made determinations, we have to have facts that will show that the bias against us is so great that a fair trial is not possible. Now, is it possible that a fair trial, when the facts show that the judge misled you on procedure on behalf of to favor the prosecution? It seems like a no-brainer to me. I would not think so, my friend.
I guess that's just, that's my current course of action.
Yep. So that's what I would do, tough guy.
All right. Well, thanks again, Mark.
You're welcome. Keep in touch and let me know, so I'll send you the template after the show, and keep in touch. Let me know how it goes.
Yeah, I'll send you an email.
All right. Appreciate the call. Right. BBC. in Chico, California there. That it's these people, when you're at the traffic level, yes, there are judges that will stick to the rules fairly close. And that's why we can get so many of these things tossed out. I got like 6 things, backups. I'm going to have to do a video with, with 5 or 6 tickets that have been thrown out. We got another one just a few days ago. And I'm really behind on doing that stuff. So there are still some judges. Hell, there's even prosecutors that have some semblance of sticking to the rules. But when it comes to traffic, wow, it's really a free-for-all. Because the majority of people there in traffic don't have the money to fight it. And when you're poor, when you're not privileged, when you don't have the money, they can really stick it to you. They can really take advantage of us. And that's why you get these things. On one hand, they're saying it's not just a trial issue. Okay, we're here before trial. I'm willing to settle right now if the prosecution has these facts. No, we're going to trial. Why are you going to go to trial when it's very clear that the record does not have sufficient facts to justify a finding of jurisdiction, personal and subject matter? Why for this is a typical example. They know that there is no evidence. I have on record an Ohio judge telling somebody, admitting that there was no evidence, that they were there at trial to hear the evidence. Why are you setting this matter for trial? Because all you got to do is pronounce the poor SOB guilty, and now it's his burden. We have to take the money out of our pocket, and we have to appeal this. And if you are in Minneapolis, Minnesota, that area, the filing fees, according to a report from last year, something like $400. The average American, more than half of Americans, $400 will put them at, they don't even have it. You have $500 filing fees in Minnesota. So if you've got to appeal and they're going to charge you for that, you can't. So this judge knows full well. They know how things are going. They know that most people don't have a few $100s to spare, that if they do that, they may not be able to put gas in the car. They may not be able to feed their family. They know how so these things are done purposely. Why else would they, when confronted with an obvious lack of evidence, prefer to force it to trial? Honest people, when something is being forced to trial, is because they have contradictory facts, or they can, no, I can show this. No, you're dead wrong. But when you confront somebody and they don't have the facts and they want to push it to trial, it's because they know they can't prevail, and that so once they find you guilty, the burden, and a big burden, shifts to us. It's definitely an us against them scenario. In fact, ask them; they'll tell you. Certainly, the police officers look at us that way. That's why they can go in and into the wrong apartment and shoot somebody, and put in headlines, and they actually put in the headlines. So you have media that's complicit here. Instead of saying an innocent man, they say with no active warrants. Why? Because he was brown. He wasn't rich and white. Two sets of rules here. One for the privileged class, another one for the rest of us. So what happened, real brief, hopefully I can get this posted too, another call of shame, and it's not done by me, which kudos, I think that's fantastic. That's what I want to see. A police chief admitting, and this is what's so important here, you ask them what their position is, and then you start challenging why they believe that is true. So here a police chief, I believe it was a police chief, is agreeing that his agency operates under the basic foundational legal claim. If you are physically in Wisconsin or Minnesota, wherever, the laws apply and give them jurisdiction over you. Which great, and I haven't heard it. I'm just going by what the Cliff Notes is, that the police chief, before he slammed the phone down and hung up on the guy, admitted that no, there was no evidence. And there couldn't possibly be evidence, because they are just literally men and women forcing strangers to give them money. That does not create any kind of obligation of protection and allegiance. It does not create what's called citizens in the state and the whole thing that There could never be evidence, because physically being in Arizona doesn't mean a written instrument from 1910 applies and creates obligations on me. Logic and facts just don't work that way. But speaking of the ruling class and how the rules don't apply, going back to the murder of Botham Shem Jean, he was an unarmed black man in his own apartment. Oh, no active warrants. And Amber Guyger, Dallas police officer, comes in, shoots him dead. This happened back in September of 2000. Well, back in the summer, about a year ago. This police officer was off duty, to the best of my knowledge. She may have been in uniform, but she wasn't on the job. She was off the clock. She wasn't immediately arrested, like I would or somebody else, for breaking into somebody's home and killing them dead. So if you see the photos, she was actually eventually she was arrested. Amber Guyger. I have the picture of her and her victim, her innocent victim, in the thumbnail for this video. And she was allowed to go home. She was allowed to go home. She was allowed to clear her social media. Although some claim that her Pinterest, she forgot to clear her Pinterest, and there were allegedly racist comments, racist things on there. Again, I haven't seen it. It's just something that was reported. She was eventually indicted. I think they're overcharging here, but hopefully they still allow murder too and manslaughter on there, so they can, so if they don't get a bunch of brain dead copsuckers, may actually convict, even if the prosecution, throws the fight. Prosecutors cry, well, we have to work with the cops. We got to work with the cops. Partners in crime is usually what you are. Yeah, maybe the cops have some dirt on you. Maybe there's some backroom deals that the cop may testify to. It may be happy to give to a defense attorney. Yeah. She was actually, and that's what's shocking here, is that she was actually charged, arrested, booked, charged, and they're starting jury selection this week. But they were nice when they did the picture. This is in the thumbnail. They, instead of getting to see her in the yellow and the orange jumper that most people are in, they put a towel around. Wasn't it? It was so nice. It was so, oh yeah, we don't want, yeah. So we know how dirty this is and how cops stick together. Because what the Dallas police officers did, what the Dallas Police Department did, was instead of searching the one who killed Jean, Amber Guyger, instead of getting a search warrant for her apartment, no, they got a search warrant for his. It was a crime scene. Do you really need a search warrant for a crime scene? It was a crime scene. He was killed in his own apartment because they went and got a search warrant to see if there was marijuana in there. So what these despicable, someone made a pretty good point about me insulting. These police officers, what they did, and it certainly wasn't one individual. This involved the prosecution, involved a judge. They went to smear an innocent man. They went and got a warrant to search to see if there was any marijuana. The fact that they tried to smear this innocent man, I got to tell you, that speaks volumes. Why would they do that? Why would they even be concerned? She went, admittedly, into the wrong apartment. It wouldn't matter if Walter White and Jesse Pinkman were in the back room. She killed an innocent man. She went into the wrong apartment. And even that is sketchy as to why she kept on trying to get in. It wouldn't matter if they had, 100 kilos of cocaine in the closet. She shot and killed an innocent man. That has nothing to do. The cocaine in the closet would have nothing to do with the facts of why she killed him. But they want to smear them anyway. Not privileged rich people. Not a part of the ruled class. So what they have to do when all the facts are stacked against the cop, what do? They smear the victim. Tamir Rice was 12 years old. He had it coming. The cops were in fear for their life. Had to do it. Daniel Shaver, son of a... he had it coming. It doesn't matter if they were screaming contradictory orders. He should have followed them. He had it coming. But he had a gun. Arizona is an open carry state. So they're picking a jury. I can't say I have any confidence that a jury is going to convict this killer. I see something going where maybe there's a wrongful death lawsuit against her and the police department. That has more of a chance of succeeding. Because you have a lawyer or a firm who wants justice. They want the truth. They want the facts to come out, all the facts, so that a jury can decide on the damages. Whereas here, does the prosecution want a conviction? Do they want justice? Well, what process? They're very few and far between. Like I mentioned last week, someone like Larry Krasner. And I think I did catch myself when I was talking about him not prosecuting petty larceny. I think it's, well, I don't advocate that. Right? Who knows? Can they get a jury that will actually convict if the prosecution doesn't throw the case? Yeah. I like to be able to see here. Hopefully it'll come out. This is part of the problem. You got a conflict of interest. Is the prosecution going to seek to find out why they did warrant for his a search warrant for marijuana? Is this information that the defense? Oh, you gotta hope that the defense counsel. No, that's backwards. Okay, I quote myself. It's on the prosecution side. The prosecution has the Amber Guyger's lawyers aren't going to want to really get into the warrant. It doesn't help. I guess maybe if they want to smear them in front of the jury. Oh, I guess yeah, that's a good point. The defense may want to use that, but they didn't find anything, as far as I know. Oh, it's just shocking at all. So hopefully, we'll have to get updates on that as they come in and see what happens with that. You would think, based on the facts, it would be an open and shut case, though. She went into the wrong apartment off duty, and she wound up shooting an innocent man. Should be open and oh, but then again, you have the Slager case. I think his name is in South Carolina. Shot a man in the back while I was running away. Jury wouldn't convict. Jury would not. There's video evidence of him planting evidence, falsifying a crime scene. That they couldn't even convict him of that. I don't care if it's an insult. Cop suckers. These types of people who think cops cannot do wrong. And that if you have any objection to what police officers do, you're un-American or you hate the cop. Oh, come on. Get an argument. Get a valid argument here. Having a valid criticism doesn't mean that you hate the subject. That's just a way of avoiding the argument. That's a way of, when you don't have an argument, when you don't have a counter argument, that's true. No, you just hate America. What does that have to, how is that relevant at all? Ay. Let's see. Someone's to Riga, I'm surrounded by copsuckers. I got to say that most of us are. Most of us. Well, depending on where you live. But that's true. So many people love the cops. You can't do anything. Someone posted, I saw in the feed the other day about a picture of a cop, praying that all of the cops get home safe that night. This thing that the attitude that cops have. What's important is that I get to go home. Really? It's a good thing that paramedics and firemen, they don't have that same mentality. If you are so concerned about your life and that you could lose it, get a safer, profession. In fact, it's not even in the top 15 most dangerous professions anyway. In fact, most of the deaths, according to this, from memory, I may be a little wrong on this, but most of the deaths that police have on the job are in car chases. They're not because they're victims of a crime. Well, why they're trying to arrest somebody. So we know we got heroes like Scott Peterson in Florida. When there's an active shooter, he sought cover. He did not go in to protect those people. No, he didn't. Funny, Dalton saying, funny, they volunteer for the job, then involuntarily get paid by the people they so-called serve with a fat ticket or threats of imprisonment or death. Such a hard job. Yeah. And I mentioned someone that I grew up with is a cop sucker, a hardcore cop sucker. And he had posted something, a politician saying that the war on police must stop. And so all I did was fact check. There's no war on cops. Do cops get shot on the job? Yes, they do. Yes, they do. That doesn't equal a war on cops. Cops kill more of us every year by a far margin than regular people kill police officers. They kill a hell of a lot more than us. In fact, they kill so many of us. I said it's the leading cause of death for black men 24 to 29. Sixth leading cause of death for them. We are more likely to get killed by a police officer than dying in a terrorist attack. So, yeah. Yeah, the number is 218-632-9399, 218-632-9399. The passcode is 2020 if you want to join me here on the big show. Some good news. I'll cover this in a little bit of detail here. That I've mentioned before with the IRS, we want to get a stay of the computer process. And we usually know we're getting a stay on the computer process because we get a 45-day letter. And then that's usually followed up by another 45-day letter. And then we get a 90-day letter or two. And then since the computer process was stopped, it doesn't escalate. Critically important when we're dealing with the IRS or tax agencies, because most of, I say all of them are on an automated system and it's programmed. If there's a 1099, a 1098, or there's a W-4 or W-2, right? And if there's reporting and there isn't a corresponding return, the computer automatically sends I don't remember what it is, a CP59 or I don't know. But they send you a form letter saying, hey, you are required to file a tax return. If you disagree, then call and fill out this form. I always recommend, and most of the success we have with the IRS is when we start with the first form letter. And so we did that with a good friend, and we had to make a number of calls. I always recommend making the calls so that you can use the statements and admissions against them. Sometimes, which is nice, they'll admit that their foundational claim is an assumption. We then use that, and we always ask for a stay. Depending on which agent you're talking to, they may or may not do that. Because generally what will happen is they'll say, well, we're not even the right department. So knowing it's not the right department, knowing that the communication is so bad, and the fact that the process is automated, that after so many days, it's going to escalate, we ask them to stop it. Sometimes they do, sometimes they don't. So look, while we are waiting for this response to be processed by the right department, please put a stay. Because look, it wouldn't be fair for this matter to escalate when it's through no fault of my own. It's because the IRS is such a, slow bureaucracy. Sometimes they do, sometimes they don't. Usually after we send in the letter, we have our statements. For those who are just listening or new to this, I've mentioned this before today. We always ask them what their foundational operating presumption is. That they're operating on the presumption that if you're physically in the United States, the laws apply, or if you receive money in the United States, that the laws apply. And then we question them on the facts to show that claim is actually true, which of course there is none. And a lot of times they admit that. If they don't admit it, but they don't give the facts, now they're acting in bad faith, and we can still use it against them because the fact not appearing is presumed not to exist. So it goes. So this is what we do. After a number of calls, and it goes. We mail the follow up, and after a month or so, we get the actual 45-day letter. I do recommend, and we're going to do this, calling to make sure that there is a stay. There generally is, but it does help to get a confirmation on the phone. So hopefully that is the last we are going to hear of that. So I think that's going to do it for the big show today. If anybody was going to call or if I missed a question or a comment, we will be live on the Wednesday show as usual. I haven't missed a Wednesday show in a while. Just won't be live a week from today, which kind of stinks because that would have been I'll be doing the show for 9/11, so we can talk a lot about that charade. And not it's a serious thing that 3,000 plus people died, but the whole cover up. That's another thing about the ruling class, how the rules just don't apply. Could you imagine blocking an investigation into the deaths of 3,000 people, actually blocking it? And George Bush walks a free man, a rich free man to this day. Once there is an investigation, he refuses to go on the road. Oh my gosh. Holy crap. Look, there are so many aspects of that, and it's hard to believe it's been 18 years. But it just goes to show that the rules do not apply to wealthy politicians. They just don't. It's extremely rare. That's like they showed that President Trump violated federal law, knowingly put out a false weather report. violates federal law? Nothing. It's one of the most minor thing, one of the, one of the more, a very minor thing. And then you've got, foreign governments spending millions of dollars at his hotels, and you got the whole thing with this vice president going, spending money at the Trump Hotel in Ireland. None of it matters. It doesn't matter. So I encourage everybody, just like this guy did with the police chief, and then we'll get that posted as soon as we can. Confront these people. Get their admission, get their, to clarify what their position is, and then tear it to shreds and expose them for the criminals that they are. Because politicians can do almost anything they want. There's not much of the line is a dot to you. We need to expose them and stop supporting them, because they are not going to police their own. It's not the way it works out. Appreciate everyone tuning in today. Thanks for the continued support of the show. If you're being attacked by a bureaucrat or want to just help support the show, you can get information on how to effectively defend yourself. And you can see documented proof of the success that we've had where the motions have been granted. So a lot of times that's happened. A lot of nolo prosequis where the prosecution just withdraws. You could do that at markstevens.net and also support the show at markstevens.cells.com. So until we are live again on the Wednesday broadcast right here on my YouTube channel, salud.